Trust Ltd, the BBC Pension Trust Ltd.
Good morning, Mr. Speaker.
Good morning, lady and my lords. What I propose to do, if it pleases the court, is to structure my submissions today so as to cover 13 headings, which may sound a lot, but hopefully when I explain what those headings are, it won't seem so much. Some are what might be regarded as particular issues or aspects of the main question before the court, namely whether or not interests covers future service benefits, on which we have a number of submissions, but we have overarching submissions in relation to each of those aspects. 2 of my 13 relate to the other 2 main issues, namely the final salary link and Bradbury. What I propose to do is just to list out my 13 headings so you can see where I'm going, what my direction of travel is, and if, for example, you have any particular questions, you'll know when the relevant topic is coming up. That may or may not be helpful, and obviously you will ask your questions whenever you feel it's appropriate to do so. Having listed them out, I'm actually going to then open our case by going through those 13 headings, giving you, pretty shortly, in most cases, what our main point is. So you can see how our case, we say, hangs together. On a couple of them I'll say a little bit more in opening because they're very pertinent, it seems to us, arising from yesterday. Then at the end of that I will turn to my more detailed submissions, some of which can be very brief, having covered matters in my opening. That's the way I'm going to proceed.
Thank you.
So my 13 headings are as follows. Firstly, the scope of this Part 8 and reserved matters. Explain what I mean by that in a moment. Secondly, what we call the BBC's linguistic odyssey, which has turned into a legal odyssey as well, particularly yesterday. Thirdly, the criticisms made by the BBC of the judge's approach to ascertaining the natural and ordinary meaning of interests in the particular context in which he was considering it. Fourthly, is there an alternative, narrow approach to the meaning of interests that the judge could or should have taken? And the way into that, for your note, is Trustee Skeleton, footnote 13. And I will need an opening to explain what we say about that in a little bit of detail. Fifthly, is there assistance to be gained from the use of the word interests in provisions other than the power of amendment, given the range of content, to use the judge's word, that interests can have depending on the context? Sixthly, what do we learn from the context in the current deed? And to make it clear, that's an area where I will particularly be focusing on the 3rd and 4th provisos. 7, what is the relevance of, or the assistance to be gained from, considering the existence of a right to terminate pensionable service, either in the 1949 deed or in the current deed? 8, the role of the actuary. 9, archaeology. 10, very important topic, the 1949 deed, and in particular the interests of active members in the period 1949 to 1955, a topic upon which there was much discussion yesterday.
1949 to
55. I hope from the submissions made yesterday that the reason for the 1955 is clear, but I'll elucidate more, obviously, in my submissions. 11, reasonable and practical effect. Courage, the famous dictum. 12, final salary link. 13, Bradbury, which I will be dealing with very shortly. By that I mean not right now, but I won't take very long when I eventually get to it. So, those are my 13 headings, and by way of opening and elucidation of all of those, but to a greater extent in some cases, I'll take them one by one. Firstly, the scope of this Part 8, reserved matters. I raise this not because it's a contentious point, but because it's a point of important background and I hope useful information. You will have picked up reference to the fact that there are reserved matters, but I'm not sure that you will necessarily have looked at what those are. You have the questions on the claim form, which you've seen, and those are in the core bundle. But in the supplementary bundle at tab 13, starting at page 280, is a letter on BBC letterhead, which is essentially an open letter, the contents of which were agreed by all three parties, setting out the basis upon which this Part 8, or this part of this Part 8, that the trial concerned, will or will not cover. And if you turn to page 281, you'll see paragraphs 1.8 and 1.9 reference to what we're calling reserved matters. There's a general carve-out at 1.8 for all matters that require factual determination. Those are out of the scope of these proceedings. At 1.9, more particulars are given without prejudice to the generality of matters set out above. In particular, are carved out for the proceedings the matters at A and B. And I draw particular attention to B. If the court were to determine that the interest of active members includes either, one, the ability of members to accrue future service benefits, or two, the ability of members to accrue any future service benefits, and that relates to, on the claim form, questions 6, 1, C, and D, most obviously. And the BBC were to propose changes to future service benefits in either respect, the trustee and or the BBC may wish to seek guidance. 1, on whether the specific changes proposed would substantially prejudice active members' interests. 2, on what, if anything, might amount to substantially equivalent benefits. And 3, on any matter that may be raised by the scheme actuary if they're asked to give any certification under Rule 19.23. Now, I flag that for your benefit, I hope, only to really make 2 short practical points. Firstly, how, if the appeal is refused, dismissed, and we are left with the answer being that, for example, future service benefits are within interests in the third proviso, how that will actually work out in practice for the actuary will be covered separately, if required, in a different set of proceedings. And to the extent that any concerns raised in this court's mind about precisely how the actuary would perform this task under Proviso 3 by some of the submissions that Malone and Friend made, many of those concerns may be dealt with in a pragmatic way in the second half of the proceedings if they are required at all. And the second point to make is that this clearly contemplates and reinforces the possibility that if a benefit is within interests in the third proviso, a change to that benefit could potentially still be made if there's no substantial prejudice, or if there is a basis upon which substantially equivalent benefits can be offered. But that's an obvious point, perhaps. One only needs to read the proviso to see that, but this is not do or die for the BBC. They are simply seeking the answer to a preliminary question, namely whether, for example, future service benefits fall at all within the concept of interest. But just because they do, if they do, that doesn't mean that they will be unable to make changes in the future. It may make it impossible, but it doesn't necessarily mean that. This is quite a sophisticated proviso in that sense. There are get-outs to make it flexible and to give them the opportunity with the trustee, depending on what the overall package of benefit changes that might be offered is, to make significant changes.
If they're interested in saving money, the two exceptions that you refer to, no substantial prejudice and equivalent benefits, not going to help, are they?
Well, that may or may not be so.
Well, not obviously.
There is of course the alternative of member consent, and this is a scheme historically where changes have been made through member consent. The introduction of the care regime, CARE, which is career average earnings, as opposed to a final salary link, was a change that was made with agreement. It's quite a complex area. It involves looking at a number of swings and roundabouts and negotiation with the unions or the individual members, collective bargaining, to see what the benefit structure should look like. But I accept the point in principle, but one shouldn't necessarily just assume that that's the end of the matter if changes are made. So that's my first point, and that's one I won't come back to. That's really background. Secondly, the BBC's linguistic odyssey turning into something of a legal odyssey. The BBC says interest means legal interests, and that in turn means rights to benefits to which a legal entitlement or claim has already arisen by reason of an active member's past service. That's the BBC's skeleton at para 20. This definition of interests, or rather of legal interests, is one that the BBC has tweaked and refined through the court process. In the High Court, the definition was existing benefits which have been earned by the member as a result of his or her pensionable service up to the date of the amendment. That's the para 72 of the High Court skeleton. No doubt the BBC has its own reasons for having tweaked that definition. Perhaps it felt that a reference to pensionable service up to the date of the amendment merely served to highlight the lack of any temporal limitation attached to the word interests in the third proviso. In the result, their tweak is substantially neither here nor there, but it serves to illustrate the obvious point that there is no temporal restriction on interests in this case, whatever they mean. It's not, for example, as it was encouraged, like benefits secured by past contributions. It's not interests secured by past contributions. It's interests. The work the BBC has done to define very precisely what it says interests means highlights the journey away from that single word that it's necessary to make. And it raises the question, is that a journey that the ordinary reader would make, either now or in 1949? There's a further important point we want to make about the definition of legal interest that the BBC advances. The BBC has, we say, taken care to avoid saying that legal interests means the same thing as benefits that have been secured or accrued, or that they mean the same as accrued rights, as they're conventionally understood. This is important. On the BBC's case, interest carries a narrower meaning than, for example, accrued rights which means that the third proviso provides active members with less protection than a fetter that protects accrued rights, such as the one in Gleeds, which we will look at under the final salary link heading, in which Mr. Justice Newey had held that for the purposes of whether or not a final salary link was attached to an accrued right, the answer was the same as in Courage, where Mr. Justice Millett had held that a salary link attaches to benefits secured by past contributions. Why is it that the BBC is putting forward a meaning of interests, a definition of interests, that is narrower than that? It seems to us that that's because, consistently with the line of Courage authorities, which the BBC doesn't seek to argue are wrongly decided, those formulations, some of which contain fetters protecting or accrued or secured benefits, those would all include a final salary link. So the BBC's case necessarily involves a submission that the ordinary reader would have a very precise understanding of what interest meant, or indeed that the drafter was seeking to identify a very precise sort of interests, or as the BBC says, legal interests that are different from benefits that have accrued or been secured, or from accrued rights. And it's important, we say, not to lose sight of how far away from the word interests the linguistic odyssey takes you. And that's without taking into account the allied legal odyssey, which the BBC necessarily then has to follow in seeking to define what the nature of the interest is of active members between 1949 and 1955, which led to yesterday's long, and we would suggest slightly convoluted attempts to locate it somewhere close to an accrued right, but not quite, because it does not have a salary link attached to it, and or somewhere close to the rights that an active member after 1955 would have because of the introduction of leaving service benefit or short service benefit. More on that in a few moments under my heading 10. The BBC's linguistic odyssey is to be contrasted with the judge's formulation, whereby interest means the interests of that person taking into account the relevant context, in this case that they are active members. In relation, I'll leave that one. If you follow that odyssey, the central question remains what the word interests means, rather than what the drafter would have meant if they'd referred to benefits earned or to benefits to which an active member had a legal entitlement or claim as a result of past service. This brings me to my third heading, the criticisms of the judge's approach to ascertaining the natural and ordinary meaning of interest in the particular context in which he was considering it. Here we rely on paragraph 55 of the judgment and what precedes it as making eminent sense, and the criticisms made of that approach are misconceived. Paragraph 55 has been highlighted a number of times in submissions. I think a question from my Lord Christopher Floyd referenced that particular paragraph, and the reference to the active member in 1949 having his eyes fixed on the far horizon of reaching normal retirement age, who would naturally have an interest in the rules of the game not changing to a substantially prejudicial way before he got there, and would be surprised to be told that his interests were confined to benefits already earned, which had no immediate value to him and which he could never realise if he left employment before NRA. The criticisms that are made of that approach in that paragraph and in what precedes it in the judgment, we say are founded firstly on picking out certain words or phrases that the judge used in an attempt to put into other words, for explanatory purposes only, the concept which he rightly considered was being clearly described by interests in the situation of an active member looking to the horizon. And looking to the horizon is something that the active member had to do, because that is what the then benefit structure required him to do, there being no leaving service or short service benefit in 1949. That approach led the judge to what we say is a coherent and logical conclusion on the particular questions he was being asked to consider, the ones I highlighted in the claim form just now, rather than some other hypothetical questions which were not put to him. It's also, we say, through that approach, consistent with the ordinary and natural meaning of interests, and it's consistent with the particular context in which it was being used, i.e., A, the third proviso, and B, against the background of the then benefit structure. And we say that his horizon approach in paragraph 55 encapsulates the essence of an active member's interests at that time. Secondly, under this heading, heading 3, there was more than a hint of what might be called the floodgates argument from the BBC yesterday. Given what was suggested was the breadth of the meaning that the judge had given to the word interests. What the judge had actually done was to look at the natural and ordinary meaning of the word and apply it in the context that I have just described to answer the particular questions on the claim form. We don't know how the judge would have applied his approach to the meaning of interests if he'd been asked the question, for example, posed by my learned friend, whether interests covered and so prevented an amendment to, for example, an administrative provision in the scheme rules, on the basis that such an amendment, for example, might in some very indirect way potentially affect the security of active members' benefits, by which my learned friend meant the amount of money in the fund to the level of the assets compared with the liabilities. So as to cause a situation potentially to arise where the balance between assets and liabilities may move unfavourably away from assets to liabilities, and risk there being insufficient funding in the scheme if it was to go into winding up to meet their obligations. I only explain that to make sure that you understand what my learned friend meant by security of active members' benefits, but in explaining it, you can see the real remoteness that concept engenders. In any event, we don't accept the BBC's suggestion that the drafter would not have intended to protect all interests of an active member, qua active member, just because that might then capture, for example, changes to the scheme's admission policy. On any view, the proviso requires the actuary to determine both whether interests are prejudiced and whether they are substantially prejudiced, so a qualitative assessment is required. In some cases that will be straightforward, basic changes to the administrative practice under the scheme, for example, in other cases less so. But the actuary would be as well placed as any professional to form a qualitative view as to whether any prejudice to a member can be described as substantial, and if an administrative change would directly affect and substantially prejudice an active member's interests, it's hard to say that it would have been an irrational or nonsensical piece of drafting to allow for that. Fourth heading. Is there an alternative, narrow approach to the meaning of interest the judge could or should have taken? And I flagged the trustee's footnote 13 in its skeleton, which you'll find in the core bundle, tab 3, page 52. The trustee notes that the B exception to the third proviso to the amendment power under the scheme envisages that, at least in some, query all circumstances, interests may comprise benefits and vice versa. The B exception does not say substantially equivalent interests. That potentially leads to a slightly different approach to the construction of the word interests in terms of its scope than the one taken by the judge. We acknowledge that. Our case is that the judge got it right on the questions that he was asked. We also note that just as the drafter did not use the phrase substantially equivalent interests in the B exception, he did not use the word benefits when referring to the relevant prejudice. Instead, used the word interests. That may suggest that there is not a direct equivalence of meaning intended between interest and benefits, but we accept that this could suggest that the drafter had in mind that the proviso would bite in respect of benefit-related interests. This would not mean that the answer to the questions on the claim form are that therefore the third proviso doesn't protect future service benefits, because it says nothing about whether this only means interest relating to past service benefits or also includes interests in relation to future service benefits. So in terms of the result, from our perspective as a representative beneficiary tasked with arguing as we are arguing, it would be the same. It is, however, a slightly different outcome from the analysis of the judge and whether or not it would meet some of the BBC's floodgate arguments. Potentially it might. We've not positively asserted this as part of our case because from our perspective as representative beneficiary, all that's necessary for present purposes is that the judge was correct to hold that on the ordinary meaning of the word, an active member's interests include their future service benefits and the salary link. That would be sufficient to dispose of the appeal. And as a representative beneficiary, we would hesitate positively to promote a construction that may make no difference to the result from the member's perspective on the particular questions on the claim form, but might if other changes not on the claim form were being considered. But we don't know what those changes are. We would be, as representative beneficiaries, in terms of what we positively ask the court to do, wary of unforeseen consequences. That said, if this court considered that it could only agree with the judge in the result by adopting this slightly more nuanced approach, we can see the force in the particular point being made by the trustee here and would not positively seek to persuade you otherwise. I emphasise that on that basis interests would be taken to mean would be benefit-related interests, not just benefits, benefit-related interests. It may be that you will receive some submissions from a learned friend, Mr. Green, on this point, which will assist, but I thought it was important at the outset to outline the representative beneficiary's position. fifth heading, the assistance to be gained from the use of the word interests in provisions other than the power of amendment, given the range of content, to use the judge's word, that interests can have depending on the context. First of all, provisions in the 1949 deed. We say that these are of little help. These are provisions other than the third proviso itself in the 1949 deed. And by that I mean, for example, Rule 22, the termination and winding up provision. These are very little help in construing the power of amendment in the current deed and rules. First point, I'll come to archaeology briefly in a moment under one of my other headings. But whilst we accept that some help can be derived in interpreting the power of amendment in the current deed and rules by considering the original benefit structure under the 1949 deed, caution is needed in respect of the BBC's reliance on particular provisions in the 1949 deed that are now in a very different form. One of the main provisions relied on is not present in the current deed in the form which it is said gave interests a particular meaning in the power of amendment in the 1949 deed. If you were only construing the current deed, you would get none of the assistance from Rule 18 in the current deed that the BBC seeks to take from Rule 22 in the 1949 deed, because it doesn't use the word interests. And that illustrates that engaging in a very detailed and complicated construction exercise of the provision in the 1949 deed can lead you to places which may mask or confuse the proper approach to the construction of the proviso in a different context, in a different deed, after there's been a significant change in benefit structure in 1955. The second point just to note in relation to Rule 18 that I've just mentioned in the current deed, this is just flagging a point for you. It's notable that Rule 18.3 treats deferreds and actives in the same way. At step 3 in the cascade of winding up priorities, both are treated less favourably than pensioners at step 1. I'm not sure that the position of deferreds in that cascade was drawn to your attention yesterday in Rule 18.3, but compare and contrast that treatment with deferreds and pensioners receiving the same level of protection in Proviso 4 in the power of amendment, distinct from that which actives receive in the third proviso. One of the BBC's justifications for the greater level of protection, as they call it, in the power of amendment in the fourth category, and in some respects they're correct to say that, particularly individual member consent rather than majority voting, was the greater preference given to pensioners generally in pensions legislation and in other deeds, in other provisions elsewhere in the deed. That's what took my learned friend Mr. Tennant to Rule 18.3, but that's not the level of preference given to the other category of member deferreds who were covered by the fourth proviso. I'll come back to that particular point when I deal with third and fourth proviso in due course. But my second point under heading number 5 about the assistance to be gained from the word interest in other provisions relates to the current deed. We say that, again, very limited assistance, if any, for the reasons given by the judge. There's one specific provision that learned friend flags and relies on, which is Rule 10.6. I'll give you, because they're very short, my submissions on Rule 10.6 now, and then we can leave it, if that's acceptable. Firstly, we say that that doesn't assist in construing the meaning of interest in the third proviso. BBC argued that the beneficiary's interest in Rule 10.6 and if you want to have a look at it while I make these submissions, it's in the supplemental bundle, tab 10, page 188. The BBC argued that a beneficiary's interest, quotes, in Rule 10.6, which is on 10.63, which is on 189, the beneficiary's interest there, which, as you may have noted, is a direct reference back to what is described in 10.61 as the beneficiary's entitlement or prospective entitlement. The BBC argues that that's being used to refer to past service rights, and this in turn informs the meaning of interest in the third proviso. The first response to that is that, again, it's an example of a word interest being used in a different context to that in which it's used in the third proviso, and it doesn't provide any useful guide to the meaning of interests of active members for the purposes of the third proviso. Again, the approach taken by the judge. Different content in different contexts. Further, even assuming the BBC's right that it's being used to refer to past service rights, all that demonstrates at its highest is that at the point that this version of the rule was introduced, the drafter didn't have in mind that future service benefits could in principle be assigned. And we note that the BBC does not suggest that the meaning of the third proviso changed when this version of the rule relating to assignment was introduced. It's also notable that in all other respects, when looking at other provisions, the BBC has encouraged you to look at the 1949 deed, but in the case of this, assignability of benefits, it didn't do so. Perhaps that's because the rule was different in 1949. It's Rule 16 at tab 2 in this bundle, page 29. And here the phrase used is beneficial interest. We don't know what my learned friend says the meaning of beneficial interest is, but again, it's a different context to the use of the word interest from the third proviso. So we don't suggest that 10.6 in the current deed assists at all. My next heading 6 is what do we learn from the context in the current deed? I will come back to this in more detail. I'll have to in due course, but in summary, we say that the different levels of protection or routes out to being able to make an amendment, even though the proposed change affects the interests of an active or other member, the different routes out and levels of protection in respectively the third and fourth proviso, and which categories of member are covered by each is a very significant point. In summary, we say that the only rational explanation, although we'd be content with the most rational explanation, for the inclusion of exception B in the third proviso, combined with the fact that only actives have their interests protected by the third proviso. I can see my Lord Christopher Floyd perhaps looking at that, so if anyone does want to have it open while I just make the summary submission, it's page 217 in the supplementary bundle behind tab 10. The only rational explanation for the inclusion of exception B combined with the fact that only actives have their interests protected by the third proviso, whereas both pensioners and deferreds have their interests protected by the fourth proviso, is that the drafter recognised that only in the case of actives do their interests include future service accrual, whereas what pensioners and deferreds share in common is that their interests cannot include future service accrual. As for the greater level of protection afforded to those in the fourth proviso, when comparing exception B in the fourth proviso with C in the third proviso, in C third proviso it's a resolution by a majority of members. In B fourth proviso it's the written consent of each such person. The reason for that must be something common to both deferreds and pensioners, but not shared with actives. Otherwise, it would say the same thing. And that is, in the case of deferreds and pensioners, that their interests are only past service rights, whereas actives have more than that. And we would suggest that the drafter is plainly envisaging that where making future service benefit changes, as for example part of a collective bargaining process with employees, that would sit well with the sort of majority vote procedure provided for in 3C. What the deferreds and the pensioners do not share between themselves, however, is the characteristic that the BBC relies on to explain why pensioners are in the fourth proviso and not actives, which is that they're old and no longer working. Deferreds who are in the same proviso can be young and working. They can be younger than the actives. They are effectively people who've left the BBC service after a requisite period. It could be early, still relatively early on in their working life, in remunerative employment elsewhere. So they're not like for like in the sense that described by the BBC with pensioners at all. As far as the fifth proviso is concerned, on its own, the judge would not have considered it to be conclusive in favour of our position, but he found it supportive, and we submit that he was right to do so. I'll explain that briefly in more detail when I get to the provisions in the current deed in due course. 7. The relevance of the existence of a right to terminate pensionable service. This will require a bit more development in my more detailed submissions. But in essence, we say that the reliance placed on the existence of a right to terminate for the purpose that the BBC seeks to use it is misplaced. In the 1949 deed, it is simply not incoherent, as the BBC suggests, to have a unilateral right to terminate contributions to the scheme, thereby terminating pensionable service and enabling the BBC to walk away from this scheme without the need to make any further contributions, whatever the actual funding level, combined with B, a bilateral power of amendment, which by being bilateral already has a restriction built into it on the ability of the BBC to deploy the power of amendment, where the drafter, under B, has made the further policy choice, further in addition to vesting it in the trustee, of increasing the level of restriction in the power of amendment through the inclusion of some fetters, which are the provisos. We say that's a perfectly rational policy choice. Can't be described as incoherent. They're just dealing with different things, but it's certainly not incoherent, which is the BBC's submission and the point that it really needs to make good if it's going to rely on that. 8. The role of the actuary. In respect of the role given to the actuary, in the third proviso, we say that doesn't help the BBC's case at all. The BBC's main objection is that there's some difficulty in an actuary valuing potential future rights. As to that, first of all, in many cases that will not be necessary. A closure to future accrual on its own, not accompanied by anything else, or a less generous rate of accrual going forward, clearly prejudices a member's interests. And in most cases, the prejudice, if that is all that it is likely to be substantial. The actuary will just need to decide if the prejudice falls one side of the line or the other. Secondly, as to that, the whole premise that an actuary could not and would not form a view as to what will happen in the future is flawed. In 1949, being able to do that as an actuary to the scheme would have been critical to determining the correct funding of the scheme, because many members would not get a pension at all, as it would turn out, because of what happened during their working life. They might leave service, they might die, etc. They would only get a return of contributions with interest. That has significant cost implications, that natural process, of which incidentally the BBC, in theory, can control through the process of dismissing members of its workforce. If they were to dismiss active members, they would have no pension rights, whatever the other employment consequences might be. So that natural or indeed influenced process, influenced by the BBC, would have cost implications for the scheme, because obviously sufficient funding to pay for n/60ths of every current active member's pension interests would not be needed, because ultimately it wouldn't be needed. The actuary would naturally have to use their professional judgment as to the likelihood of the scheme needing to pay out a pension at all, and that in turn would inform the necessary funding level of the scheme, i.e. how much the BBC would have to put in under the contribution rule. We'll come back to that in due course, but that's just the general principle. And allied to that, thirdly, in particular in schemes with a salary link, actuaries need to and do form a view as to when members are likely to leave service and what salary increases they're likely to have whilst in service, because those considerations determine the value of the accrued past service rights. This is now in a scheme with leaving service benefit, obviously, a modern day deferred benefit scheme, a scheme with deferred pension rights. And it helps to determine the value of the total accrued past service rights within the scheme, because either as and when members leave service and become deferred pensioners, their rights, the value of their rights as at the date that he leaves service, are under both scheme rules and statute revalued during the period of so-called deferment between leaving service and actually reaching normal retirement age when they take the pension. The pension they take will depend on what the value of their accrued rights were when they left service, revalued each year in the intervening period by a particular rate. Conversely, to the extent that the actuary is prospectively looking at the population of current actives who will not at some future point leave service before NRA, but will remain in active service all the way to NRA, he'll have to take account of salary increase year on year during that period, and the rate of salary increase will not necessarily be the same as the rate of revaluation on deferred pensions. So that is a very important compare and contrast, and involves the actuary making assumptions about the way in which people will leave the scheme and when across the general population of current active members. I'll move on now to archaeology, heading number 9, if I may. To the extent that there's any parting of the ways between us and the BBC on the law, it's on the relevance of what was said in Barnardo's, both by the Court of Appeal and the Supreme Court, about the use of archaeology, and specifically the fact that members would not necessarily have had knowledge of prior deeds. A point made by my Lord Justice Lewison in the Court of Appeal in Barnardo's, and picked up in the Supreme Court, as you saw when my learned friend made his submissions. We say that the fact that members would not necessarily have had knowledge of prior deeds is a factor that remains relevant at all times, not only in circumstances where the deed or clause that is being interpreted has been completely rewritten when compared to earlier deeds or clauses. That may affect the weight that you give to that factor, but it's certainly a relevant factor. All of that said, which is in the scheme of this case and the rest of the authorities dealing with archaeology, probably a relatively minor spat, there is no reason we submit in principle why the judge could not have started the exercise of construction with the 1949 deed, provided he exercised an appropriate level of caution. That level of caution about going back to the beginning first and working forwards will need to be calibrated on a case-by-case basis. And that's why it's very much a matter for the judge to consider in the round the appropriate place to start and how to put together the competing arguments about the construction of a provision in the deed that is the provision that he's actually being asked to construe, weighed against the arguments of construction about a provision in a deed that is over 70 years old and in relation to which there's been a significant change in benefit structure and in context through the substantial change in certain important provisions that the BBC relies on in relation to its 1949 construction argument. This judge had the benefit of hearing full argument on the construction of the power amendment in both deeds, as effectively this court is going to hear, and only after he'd heard that did he decide in what order to set out his findings. We say that's in accordance with the approach advocated by Lady Justice Arden in MNRPF, or Stenner. In due course I'll develop that to the extent I need to. But in summary, we say he was right to approach what is a unitary exercise of construction in the way that he did in this case, although it doesn't matter, because if you start with the 1949 deed, you get the same result. We do say that there are real risks in this case in allowing the construction of the power of amendment in the current deed and rules to be driven by the construction of a provision in the 1949 deed, that's to say the termination provision, Rule 22, that's very different to the current winding up provision. The same point applies in respect to the differences between the third and fourth proviso, where the BBC focuses entirely on the fourth proviso, protecting vulnerable pensioners, when it's in fact protected deferred members as well for nearly 70 years since the change in 1955. 10th heading, the 1949 deed interests of active members in the period 1949 to 55. First subheading, I need to say a little bit about this in opening, and I hope you'll bear with me to give you our overview. First subheading, how important is an understanding of the nature of these interests to the overall construction exercise facing this court? Well, if the construction exercise is firstly construing the third proviso in the 1949 deed, then understanding the nature of those interests is probably critical to the exercise of construing the meaning of the third proviso. However, even in the context of the 1949 deed construction exercise, it's not necessary to descend to the level of detail covered by the BBC's submissions. Please note that the judge didn't make any positive or precise findings about what the nature of the active member's interest between 1949 and 55 was. And he was right not to feel the need to do so. What he did do in para 55 in the sentence that just precedes the passage we were looking at previously about colloquially looking at the far horizon, in the sentence, there was no prospect of a right to a leaving service pension arising before then. What he was doing there, and all he was doing there, is outlining what the interest of an active member in 1949, and in particular that part of their bundle of interests that was referable to past service, outlining what that was not. He was saying it's not the same as a leaving service pension. And we say that in doing so, he was absolutely right. He inevitably had to accept that there was no prospect of a right to a leaving service pension. He didn't have to do more, however, because he wasn't construing the phrase rights to benefits to which a legal entitlement or claim has already arisen by reason of the active member's past service. That's the convoluted phrase which the BBC uses to describe what is meant by interests, the entirety of what is meant by interests. He didn't have to construe that phrase to see whether the interests of active members at this time fell within that phrase or definition. Rather, he was construing interests. And he was quite clear, as we all are, that even though those interests fall short of a leaving service benefit, or even on the BBC's own case, short of an accrued right, they are still interests. So the past service interests, however they are to be precisely legally categorised, are certainly interests. But that's not all that is interests, according to the judge, and we say he was right to do so. But specifically focusing on the extent of the rights or interests that members had in this period, and my learned friend's submissions yesterday, to the extent that those submissions were intended to persuade this court to take a different view to the judge and hold that active members had already earned through past service something similar to a right to a leaving service pension, to that we say two things. First, that is obviously wrong. And you can say that without needing to provide a precise characterisation of what, if anything, active members had actually earned. They had no such right, a right to a leaving service pension under the rules. And that's the end of that point. Secondly, you don't need to do any more than that. The question of what the true, precise legal characterisation was of the interests of active members back in 1949 isn't straightforward. You could probably have a Part A just on that. And if, for example, hypothetically, the FETA the proviso didn't talk about interest, but talked about protecting accrued rights, would that apply or would it not apply? That's a different debate and not a straightforward one. And we would respectfully discourage the court from being drawn into an attempt at that level of precision, which isn't necessary. The judge didn't find it necessary. He had a simple solution and the right solution on this approach. What we do invite this court to do instead is to endorse the thrust of the reasoning of the judge, which we say, rephrasing it to some extent, but it's the thrust, can be encapsulated in the following propositions. 1. A member in 1949 who understood that a pension was a reward and an incentive for long service would not naturally have thought of themselves as having a legal entitlement or claim to a pension based on past service prior to them reaching NRA. That's prior to them reaching NRA in service, having completed 10 years of pensionable service. 2. Due to the absence of short service benefits or leaving service benefit, a member in 1949 would naturally have understood that they needed to perform future service with the BBC to obtain any pension at all, and that it was their interest in performing that service that the third proviso was therefore protecting, with a view to that future service securing them both their past service pension and their future service pension. We say that is both the more natural reading of interest as it appears in the third proviso in 1949 and the correct one, because whilst in the scheme with leaving service benefits, an active member can be thought of as having earned pension for each year of service, subject to the contingency of making it to NRA, the same cannot be said of an active member who must perform future service to obtain that pension. Fourth proposal, proposition, is this. In the context of talking about what has been earned by past service, which of course is not the question before the court, the BBC is conflating the contingency of making it to NRA, which applies to a conventional short service or leaving service pension benefit, with the necessity of performing future service before any pension has been earned, banked or accrued at all. Fifthly, to put the argument another way, if the term interests in the 1949 deed includes an interest in a future pension, as both parties agree that it does, we only agree in part as to what the components of that future pension are, but conceptually we agree on that. That is something that can only be obtained and is contingent upon the performance of future service. On that basis, it's not logical or coherent to exclude from the scope of the word interests the future service benefits that would also be obtained by the performance of that future service. You cannot apply interest to one part and not the other when you look at it in that way. We say as our sixth proposition under this subheading that the propositions we have just put forward provide the answer to the question posed to my learned friend by Lady Justice Falk yesterday at transcript page 119, line 19 onwards. Quoting from my lady, I think maybe the key distinction you are drawing between what you just described, earned rights, so many 60ths by reference to years of service already undertaken, and future service. What I am struggling with is in 1949, when there was not a leaving service pension, your so-called earned pension is entirely dependent on you remaining in this employment or in employment with the BBC until you are age 60, And I'm trying to understand the difference between that and a future pension. The future years, which you say are not covered, which is similarly dependent on you staying in employment with the BBC. The correct answer to that question we submit is that there is not a sufficient difference for one rationally to fall within the interests of an active member and the other to fall outside when you take the approach set out in our propositions and the judge's correct horizon approach, which is the same as ours in paragraph 55. What is most definitely not the answer to my lady's question is the answer that my learned friend gave, namely the distinction, if I may say so, is you have earned one, you have not earned the other. That's wrong. Next proposition, in that context, we note that the learned friend also sought to say that the position in terms of earning a pension was the same in 1949 as it is now. So at page 118, lines 10 to 16, he says of a member under the 1949 deed, leaving before his normal retirement date, quotes, he cannot realise the value of the pension before then, but that is true of modern day pensions. Pensioners' members are all building up a normal retirement pension which will become payable at age 65, but they cannot cash it in early. Even if they leave service, they do not get the money. They just get an alternative pension provided at age 65 from the scheme. That is the deferred pension. But, with respect, that's not correct. At least not in the sense required to meet the point being made by Milady. A modern deferred member has become entitled to a pension, albeit contingent on reaching NRA, solely due to their past service. But also, they have a statutory right and a right under the rules of the scheme. Usually those overlap, but all schemes have transfer rules. And that right is known as a cash equivalent transfer value out of the scheme, with those monies being paid into another occupational pension scheme. So my learned friend's right, they can't take the money and spend it. It still has to be used for a pension at normal retirement age, subject to various irrelevant exceptions at the moment. But they can literally cash it in the sense of taking it to another pension scheme. It's portable. And although we don't need to enter into a detailed analysis of what would have been the position as regards transfer rights for active members in 1949, because in those days, perhaps because there were not leaving service benefits, transfers of value out of schemes like this didn't happen and conceptually couldn't happen, if you think about it. So there's a very important difference. I'll just flag it for you, but the statutory right to take a transfer is reflected in the current rules of the scheme. You don't need to look at it at this stage. Rule 12.1, that's Supplemental Bundle, tab 10, page 196. So a deferred member can take the value of their pension in the way I've described, and that statutory entitlement reflects the fact that a modern day deferred member has earned a pension from their past service, which is completely different from the position of a member in 1949. Under my heading of how important is an understanding of the nature of the active member's interests in 1949 to the overall construction exercise facing this court, I've dealt in this part of my opening with construing the third proviso in the 1949 deed. How important is it when construing the third proviso in the current deed? An understanding of the nature of those interests, which ceased to exist 69 years ago, is not critical to the exercise of construing the meaning of the third proviso in the current deed. But it does positively, to the extent that one needs to investigate that, and the judge did investigate it, up to that point, it actually positively helps the representative beneficiary's case, because the change in 1955 provides a coherent and, we would say, compelling reason for preferring our construction of the current third proviso. For this reason, through the fact that the fundamental structural change in the benefit structure in 1955 that changed the nature of the rights of active members from that under the 1949 deed, that's the historic explanation for the need from 1955 onwards to find a place to locate the protection required for the interests of deferred pensioners, those who left service before NRA with a leaving service pension. And as we've previously outlined already in this opening, and I'll come back to it in more detail in due course, the location chosen for the deferreds is the fourth proviso with the pensioners rather than the third proviso. That suggests that the drafter understood that the interests protected by the third proviso went beyond just past service interests and extended to future service interests, and proceeded accordingly by allocating the deferred to the fourth proviso.
And that was, just going back to the wording, that's a deliberate, clearly deliberate choice, because is it then that this concept of active member gets introduced?
Well, I'll need to dig around a bit, if I may, to take
because, I mean, at other points, the point gets made that a draftsman of a later change doesn't necessarily think about or...
Well, let me see if I can help you.
I mean, it looks like it's
yes.
been deliberate, because at some stage the concept of active member has been
Yes, but
introduced.
at a later stage, I was going to take you through the deeds to show you, but in summary, the concept of capital A, capital active, capital M member is introduced into the definitions.
But I think that's later.
It is.
It is
According
later. To the page I'm looking at, which is from the BBC Skeleton.
Yeah.
That was in 1996.
Correct. That's correct. Prior to that, the proviso was essentially in the form in which you see it in the 1949 deed. Can I just take you back to that to remind everybody what it says? I think I can take this quite quickly in this way. So if you go to page, tab 2, page 14 is the start of the third of the power of amendment in clause 25. At 15, capital D, which is effectively the fourth proviso, take effect as regards any person not being a member. Okay, so right from the beginning, the fourth proviso only takes effect in the case of someone who is not a member, which sounds a bit odd in modern parlance,
Yeah.
but member is defined in the definition section, which you will see on page 6. Sorry, well, that just tells you members are such persons as are, for the time being, members of the pension scheme in accordance with the rules. And in the rules, the definition of member appears on page 18. A member is a person in the service of the corporation. So, by exclusion, the fourth proviso applies to pensioners only because there is no concept of a deferred pensioner at this point in time. Once the change to the leaving service, once the provision of leaving service benefit arises in 1955, which you see at tab 3, page 40, where Rule 8, which is the rule that gave you only contributions with interest back under the 49 deed, is extended to include an option at B of a yearly pension. That's your leaving service pension. Only option A existed under 1949. So you now have the concept introduced to the rules of a new class of person, of benefit, what we nowadays call a deferred pensioner. Now, no amendment was made to the proviso at that point. But we say, and I don't think this is controversial now, that it is obvious that the draftsman would have realised that deferred pensioners needed to have their rights protected in the same way as active members and pensioners. And the only inference to be drawn is that the drafter assumed that the proviso, fourth proviso, was apt to cover this new category of deferred pensioner.
Because obviously they are still not members, they have left service.
Yeah.
And
So,
the definition of member
yeah.
hasn't changed.
And that is the same, and in the current deed and rules, the matter is made clear by the definition of deferred pensioner as someone who is entitled to a pension. But it would have been understood all along that a deferred pensioner was entitled to a pension and was not an active member, and therefore was in the fourth proviso. So that's the way it happened. So it didn't require in other words, in 1955, it didn't require an active positive amendment, but it must have required a drafting decision, which was to do nothing. Because the fourth proviso was...
Another way of looking at it is to say that the scope of proviso 4 changes as the various underlying entitlements, rights, interests, whatever you want to call them, under the scheme change.
My Lord, precisely. That's what Lady Justice Arden contemplated in RPF and Stenner, that the meaning or scope of a provision can change due to the underlying circumstances. I agree that that is another way of putting it. Yes, thank you.
Just one other point on archaeology, if I may, while I've interrupted you. My concern about archaeology is not simply because the members don't know what's been in previous iterations of the scheme, but it makes life much more difficult for the trustee. If the trustee's got to trawl back through goodness knows how many different iterations of the scheme in order to find out what it can and can't do.
My Lord, I agree. Also, what can happen, and in the cases where courts have started at the beginning and been happy to do so, the initial construction exercise probably wasn't very different from the construction exercise if they'd started at the end. Here, it is. What's happened here is that the court has ended up construing two completely different deeds separated by very large number of decades, in great depth. The way the judge worked it out was to only say as much as it was necessary to say about the 1949 deed in order to meet the arguments that have been based upon it by the BBC. And he therefore was able largely to resist temptation in his judge to carry out what is a complicated in itself construction exercise in relation to 1949. But that's another, in cases like this, and that's why I said it's very case specific. In cases like this, that's another danger. May I therefore move on, if I may? I actually went straight to my heading 10, the 1949 deed, having skipped over 9 archaeology. No, I didn't. I'm sorry. I did archaeology. Thank you. 11, reasonable and practical effect. The famous dictum from Courage. In summary, 5 short points. This gets the BBC nowhere. Secondly, their case on how to construe the proviso, in effect, asks the court to favour the commercial interests of the BBC and falls foul of Bernardo's paragraph 28. And I will just show you that because it's so short and it's so telling, we say. This is appendix bundle 3, tab 27. This is the 8th point in Lord Hodge. The court must construe the scheme without any preconceptions as to whether a construction should favour the sponsoring employer or the members. Relying on what Lady Justice Arden said, she was then in British Airways, and reiterated and to some extent expanded on in her judgment in MNRPF later. The sponsoring employer's gain may be the member's loss and vice versa. We say that the relevant inappropriate preconception here, in the BBC's case, is that power of amendments should always, where possible, be construed so as to enable the employer to control its costs to the detriment of active members. In effect, the BBC's case on this assumes that any consideration of commercial exigencies, which is the wording that Mr. Justice Millett used in Courage, and I'll come back to this in more detail later, but that necessarily ends up with the conclusion that the employer's commercial position in terms of the cost of providing benefits should be followed. That just doesn't sit with Bernardo's paragraph 28. Furthermore, and separately to the general point about costs to the BBC, the other point they rely on is the disparity in pension costs within the scheme relating to those who are earning final salary benefits or salary-related benefits, defined benefits, on the one hand, and pension costs without the scheme, outside the scheme, for employees who are given a different sort of pension because they joined service much later than those who are in this scheme earning defined benefits. They rely on that disparity as another reason to construe the power of amendment so as to permit the costs within the scheme for these members whom we represent to be cut in order to make them more comparable with the terms that they've agreed contractually with a whole load of other employees who are nothing to do with this scheme. And we say that you only have to put that proposition in that way to see that that cannot be a relevant consideration. That's the costs of members, employees' pensions in other arrangements outside of this scheme is an external BBC HR issue, not to be taken into account in construing the power of amendment in this scheme designed to protect only the interests provided under this scheme. It's not there indirectly to protect or promote the BBC's ability to deal with the interests of the costs of the interests of members in other schemes. That's what we say about reasonable and practical effect. 12, final salary link. Very shortly, if you're with us on the correct interpretation of interests, in that it protects future service benefits, then it follows, as my learned friend made clear, that any objection to it protecting the salary link will fall away. But on the premise that the court concludes that the proviso only protects something akin to past service rights, not, of course, past service rights in the accrued sense, that's the distinction that they seek to draw, then we do say that without challenging the courage line of cases and the reasoning in those cases in which benefits accrued or secured have been held to protect the final salary link, there's simply no room for the BBC to say that this fetter is narrower and protects less. In short, consistently with the reasoning in the courage line of cases, members have earned or banked a right. This is modern day members, obviously, not 1949 actives. Modern day members have earned or banked a right to a link between their nths and whatever their final pensionable salary turns out to be. If it's somebody who's in the final salary part of this scheme, if it's a career average member, the same point arises with a slightly different definition of what the relevant pensionable salary is. But whatever that relevant pensionable salary turns out to be is on the authorities part of the right earned or banked through past service. 13 Bradbury, even more briefly, it's clear from the report of the case that the scope of the power amendment was not an issue and was not considered by the Court of Appeal in that case. Further, the Court of Appeal's decision in that case is, as it happens, perfectly explicable on other grounds. I may touch on that briefly later, but the point is developed already in learned friend Mr. Green's skeleton, with which on this limb of the argument on Bradbury we would agree. That's the end of my run through by way of opening on the 12 headings. Propose to develop those points to the extent necessary by starting with where one might expect me conventionally to start, which is any comments that need to be made about the general approach to interpretation, excluding what I'm going to say in due course about archaeology and about reasonable and practical effect. That leaves, in essence, the points on the importance of the text that is used in construing a pension scheme. I'm really just going to flag up where you'll find our position on this in our skeleton argument. I don't think these need any elucidation or significant elucidation now, unless the court has any questions for me on them, given the way my learned friend put his position on this yesterday. These appear in our skeleton starting at paragraph 11 under the heading Principles of Construction at page 60 in the core bundle, and the essential point is that the exercise of construction is essentially one, I emphasise the word one, unitary exercise. This case, it's tempting to suggest, involves two separate but overlapping construction exercises if approached in the way that the BBC is approaching it. But it's important that it's essentially one unitary exercise. At paragraph 12, we emphasise the words of Lord Hodge at paragraph 13 in Bernardo's, which are familiar and highlighted in the bundle, and emphasise at paragraph 13 the weight that needs to be given to textual analysis,
And we suggest that the approach that we have taken in our skeleton thereafter and will take in these submissions is in line with that. That's, I think, all that needs to be said. There's nothing controversial about that. And your lordships will judge for yourselves whether we have followed that guidance in the submissions that we make applicable to this particular case. With that introduction, I want to make a few submissions on the ordinary meaning of interest and the approach the judge took. These submissions are relevant to my heading 2, the BBC's Linguistic Odyssey, 3, the criticisms made of the judge's approach, principally those. What's the natural and ordinary meaning of interests? The judge doesn't come from a background of specialising in pensions. In that sense, he came to this power of amendment with relatively fresh eyes, which we submit he used to very considerable advantage and very sensibly. And he concluded that, para 41, as a matter of ordinary language, the concept of interest does not seem apt to suggest that the intended division between matters which are protected and matters which are not is marked by the fault line between the benefits already earned by past service and those which are yet to be earned in the future. That fault line is an important component of his reasoning that leads up to the conclusion at para 55. You may remember when I was opening this area earlier that I obviously placed heavy emphasis on paragraph 55, but I also suggested that what precedes it is important, and this is an important paragraph. The importance of reading that, to your lordships, is that we suggest that it's immediately obvious that he is seeking to find the applicable ordinary meaning of the word interests, or content, as he used, in a particular context. The suggestion yesterday that he was looking at this, these words were not used, but in such a broad and flexible way, and that it was rather like looking at it in a vacuum, and he defined interests so broadly that he couldn't be right, because that would be far too broad an approach, is wrong, because he's focusing here on interests as it applies to the very fault line that the BBC is seeking to set up within their own definition. We say paragraph 41 is the conclusion of a sophisticated non-pensions expert reader of the Power of Amendment, and we commend it to this court. We suggest it's not tenable to think that an ordinary reader would reach a different conclusion when approaching the question in the way that the judge is approaching it in paragraph 41. In particular, an ordinary reader would not detect the restriction contended for by the BBC, namely that an active member's interests are restricted to, and I'm sorry to repeat it, rights to benefits to which a legal entitlement or claim has already arisen by reason of the active member's past service. Although I'll deal with 1949 later in these substantive submissions, I've already said enough about 1949 for it to be apparent that our submission is that still less in 1949 would the ordinary reader detect the fine distinction necessarily contended for by the BBC, i.e. that between 1949 and 55 this, namely interests, did cover a right to a return of contributions and the more remote anticipation of a pension at NRA, but did not include the additional component of their pension that under the rules they would also receive at NRA if they met the same future contingency of remaining in service. So that's the future service pension in addition to the past service pension. And as we've said in our skeleton, relying on paragraph 15 of Bernardo's, in the context of a pension scheme, the ordinary and natural meaning of the word should attract particular weight. And that is what we say the judge did there. It's obviously right that other factors weighed in the balance could lead to a different conclusion. But the BBC's case is that the ordinary words support their case as much as it does the representative beneficiaries. We don't think it's that close a competition, with the greatest of respect. The way the BBC puts this is to say that the representative beneficiary adopts the broadest possible dictionary definition of interest, the object of any human desire. And that as such, the competition is between different degrees of restriction to the meaning of the word interests. It's right that we, the representative beneficiary, don't contend that interests, as it appears in the third proviso, has a meaning as broad as any human desire. And nor did the judge think the meaning was that wide. But that doesn't mean that the debate or competition in this case can be put in such simplistic or superficial terms as thus being between different degrees of restriction in the meaning of interest in the context of this scheme, which, for your reference, is at paragraph 4 of the BBC's supplemental skeleton. That is akin to saying, as the BBC is effectively saying, that the ordinary words support the case as much as it does the representative beneficiaries. And as I've just said, that's just wrong. When it comes to the essential starting point in the construction process of considering what the ordinary and natural meaning of the word interest tells us about the way that word was used by the drafter in the third proviso, neither the judge nor the representative beneficiary has approached this question of construction as being finely balanced in terms of the competition. What we say is that interest in the context of its use across the different provisions in the TDR, that's the trust deed and rules, has a single broad flexible meaning which can and should, because of the context, be taken to be referring to or identifying only the interests that are relevant in that context. E.g., in a provision referring only to pensioners or deferreds, this only has the content meaning that interests are referable to past service, as those are the only relevant interests those groups have. I think that was the point that my Lady Justice Falk was making yesterday, and we reiterated in the way that I just have. And we say, furthermore, that in essence is what the judge was saying at paragraph 51, the judgment. Those are my friends' submissions, seductive points of analysis, but ultimately I'm not persuaded by them. The reason is a simple one. I do not see why the word interest has to have precisely the same content in every context in which it appears. In fact, it seems to me that it has an inherent pliability and is being used precisely in order to allow the content it describes to differ as necessary, according to the context in which it appears and the identity of the party or parties affected. I do not see this as a matter of interest having a different meaning. It has the same meaning, which is to refer to matters of relevant concern. Relevant, underlined, we submit. The point is rather that what are matters of concern will differ according to the context and the identity of the party or parties whose interests are described. That is the judge's way of putting the submission that I made just now, and we suggest that it's correct approach and supports our overall submission that the judge's approach to ascertaining the meaning of the word interest in the particular context in which it requires to be construed, which is the third proviso, was correct.
And do you also say that what are, to use a judge's phrase, matters of relevant concern depend not only on the context and identity of the party or parties whose interests are described, but in the case of the power of amendment, the particular amendment under consideration?
Yes. And which is, if I may say so, with respect, my Lord, a helpful reason to remind the court of what I said earlier, which is that the judge was answering a specific question. He was looking at, in the case of future service benefits, a specific change, so as to decide whether interest covers the benefit or the interest there that is being changed. So yes is the answer to your question, but that explains why the judge took the approach that he did in the paragraphs that I've highlighted, which, just to remind the court, are 55, 41 and 51. But I do rely on all that the judge says from 39 through to 55. As I said, it's a coherent piece of analysis that progresses to the conclusion at 55. It hangs together, and we say it provides the correct answer. It's worth focusing on, just for a moment, on paragraphs 42 to 43 within that section as well. This helps to identify the judge's reasoning. It seems to be natural focus of the inquiry is on the position of the active members have under the terms of the deed as they presently stand prior to the proposed amendment compared to their intended position if the proposed amendment or modification comes into effect. We say with respect that's obviously right. And then to go on, are their positions going to be different under the proposed amendment or modification? Yes, logically, absolutely correct. If they are different, then it seems to me inescapable that their interests are affected. And position doesn't mean position in an entirely unlimited sense. It obviously means their relevant position. And a change that seeks to mean that thereafter they will no longer be accruing the pension in every year of their service, to which they are currently entitled under the rules. That is their current entitlement, which is going to be changed. That is certainly a change in relevant position, and as the judge said, change in interest, or an effect on an interest. And he reinforces that at 43, because he says in the second line, even if such benefits are left entirely intact, the dealing rules may nonetheless be amended or modified in a manner which puts the active members in a different and potentially worse position for the future. If that happens, I find it difficult to see on what basis it can be said that their interests are not affected. Absolutely, we submit.
Well, the only basis on which it could so be said, in accordance with that last sentence, is if interest has the narrow meaning. So there is an element of circularity in that argument. If what the exercise you're embarked on here is trying to discover the meaning, and say, well, I can't see any reason why their interests are not affected, doesn't really advance the argument, does it?
Well, he has in his mind a concept of what interests means. He's linking it to position, I think, and I agree that without that important linkage,
underscored interest.
yes.
It's a point that's made against you that
Yes.
this whole passage is circular reasoning, but you say
I'm trying to unpick it to suggest that it's not by emphasising 42 and he's linking interest to position in what we say is a concrete conceptual way. It's there. It's the position of the member qua as active member, and not in some more general or amorphous way that the judge is talking about.
saying that there's a real sense in which their position is worse after the amendment than it was before.
Yeah. Yeah. Because they currently have an entitlement to carry on working. And that's not a sort of that's not a small thing, particularly in this scheme, which was set up as a long service scheme. It was set up in a way that was designed to encourage members to stay in the service of the BBC after the corporation was set up in 1948-49 under a royal charter as a new broadcasting organisation, totally new world, huge recruitment process, and it's perfectly clear from the, and this is a conventional structure in many pension schemes at this time. It's not unique to the BBC, but the point is still valid. It's there to encourage, indeed, until 1955, require members to stay in service until the very end. So that entitlement, unless there is an amendment to continue to accrue future service benefits, is structurally very important in the scheme, and that's why it isn't absurd or far-fetched to suggest that when the drafter used the word interest rather than something much more restricted like accrued rights, he meant something much more than just accrued rights.
Okay.
Against that, apart from the circularity point, the BBC suggests that interest in the third proviso means the member's legal interests, which is a concept they then define as per paragraph 20 of their skeleton. We suggest that there's little point spending much time debating what the phrase legal interests would mean in this context, because the drafter didn't use that phrase. That's the BBC's drafting. And it's the BBC that's provided its own definition of that phrase. And as I've just said, in answer to my Lord's question, not only are those not the drafter's words, other words that the drafter could have used, such as rights or even accrued rights, or accrued interests, or interests secured by contributions to date, if he was interested in the concept of interest but wanted to impose a time limit on it, as was imposed in Courage on the concept of benefits, he could have done so, but didn't. If I can just pick up some points made by the BBC in their supplemental skeleton. Their supplemental skeleton is at tab 4A in the core bundle. And I'm looking at paragraph 5. They suggest that at our skeleton, paragraph 35, we suggest that future service benefits are themselves legal interests in the sense contended for by the BBC. They are not. I'm not going to take you back to our skeleton, but that's not a correct characterisation of what we were saying in paragraph 35. It's wrong. We are not saying they're legal interests in the sense contended for by the BBC. As I've just emphasised, we try not to engage too much in trying to construe alternative formulations of words or phrases put forward by the BBC. In short, we say the default position is, without a rule change, one of continuing accrual. And we say that one can refer to that default position as, quote, a present right, in the sense used by the judge at paragraph 47. If that's a legal interest, yes, of course, but that's not the route in to finding the answer to the case, is starting by suggesting that it has to be a legal interest, which means what the BBC says it means. Just because the accrual is contingent on future actions, such as the employee not being dismissed or the amendment of the plan, consistently with the power of amendment, doesn't mean that a member had no such present right in the first place. Again, we don't say a member has a legal benefit or claim to a pension based on past service. Into the future, that's the BBC's definition. I think that's all I need to say on that. In paragraph 6 of the supplemental skeleton, we are attacked for saying, as set out there in our skeleton at paragraph 36, that an active member has an interest in the sense that at any given moment the deed and rules determines his entitlement to a pension calculated in a particular way if he continues in pensionable service. And to this, so the RV's argument goes, is to be contrasted with the future pay rise, which only happens if the BBC varies the employment contract. Again, that's not the way the judge analysed the matter. All I'm going to say is that despite these various attacks in these paragraphs in the supplementary skeleton, the general point that we're making in paragraphs 34 to 37 of our main skeleton is consistent with what the judge said at paragraphs 42 to 46. It's clear from the 42 to 46 of the judgment that the judge did not think interest meant enforceable legal claim to benefits earned by past service. He thought the meaning was broad and relates to the position under the scheme as it presently stands. And that's so whether or not you accept his gambler analogy as being entirely opposite. The thrust of what he's saying is clear from all of the paragraphs that precede. There's one point I should pick up so that I can make it clear what we mean in our skeleton. It's pointed out at supplementary skeleton paragraph 6. 1A, that our point ignores the fact that at any given moment in the deed and rules, at any given moment the deed and rules is subject to the power of amendment, so at that moment the deed and rules does not determine that the active member will receive any particular pension if his pensionable service continues. Furthermore, the DNR also contains powers to terminate accrual at any time, and there is no warrant for assuming that this power will not be exercised. In any event, the BBC is not obliged to continue the active member's employment. We say that's a slightly unfair reading of what we say in the penultimate sentence of paragraph 36. What we should have said is that their interests are governed by the provisions of the deed and rules in force at any particular time prior to any amendment of the rules. With that correction, that's entirely consistent with what the judge said in paragraph 42. It's really just a semantic attack in 6A on what we've said. The point at supplementary skeleton 6B is about the right to terminate, and I'm going to deal with that in due course under one of my other headings. Those are my submissions on ordinary and natural meaning of the rules. I propose to now turn to the third and fourth provisos. You can have those open, if helpful, at tab 10, page 217. So as I've outlined in my opening, one of the key textual features of this power of amendment that's relevant to the issues in the case is the fact that it contains different provisos for active members on the one hand and deferred members, pensioners and their dependents on the other. Some observations as to how the power of amendment works may be helpful, just to reinforce some of the points that have already been made in submissions. First, the power is vested in the trustee with the consent of the BBC. That means the trustee must decide consistently with its fiduciary duty whether any particular amendment should be made, and the BBC, when deciding whether to consent, must do so subject to the imperial duty of good faith. Important restrictions already are on the use of the power of amendment, built in, naturally built in. The next question in terms of the operation would be whether the interests of the active members are certified by the actuary as being affected. That's the verb used. If they are, then there are three sequential routes out under the third proviso under which the amendment could be made. Firstly, a certification that although they're affected, the interests are not substantially prejudiced. Secondly, certification that substantially equivalent benefits are provided or paid for by the BBC or the trustees or provided under any legislation. I'm not going to say any more about that than my learned friend said yesterday, the legislation part. And thirdly, the alteration or modification is approved by resolution. Just looking at the fourth proviso, as I've already mentioned previously, it applies to any person not being an active member who's entitled to a pension. It doesn't expressly refer to a deferred member or to deferred pensions, but the category is persons entitled to a pension who are not active members. And if you would like just to see at this point, Milady, the reference to deferred pensioner that I mentioned a few minutes ago, it's on page 116 in this tab. Deferred pensioner means a member who has left service entitled to a pension not yet in payment under the scheme. That's that is only a clarificatory definition and would have been conceptually the status of deferred pensioners in the minds of the draftsman before that definition became inserted into the rules. But it makes the application of the proviso on its face explicitly clearer. As I've already submitted, when the scheme was first established, there was no such category of member. I've shown you Rule 8. No, I'm sorry, I showed you the new Rule 8. Can I show you the original provisions that just make this good? If you go to tab 2, 1949, and you look at two relevant provisions, one is Rule 6, which is the normal retirement pension. Important just to emphasise the wording that creates the effect that we have been talking about. This is page 22. A member who retires from the service of the corporation on or after attaining normal retirement age, having completed 10 years of pensionable service, shall be entitled to a yearly pension, and then it sets out the amount. So emphasise, as I did, from the service of the corporation, as it stands, unless and until you work all the way through with the BBC until normal retirement age, you don't get any benefit under Rule 6, which is the driver, which it gives you your pension if you get anything. Normal retirement age is 60 years. I'll just give you the reference, that's page 18. If you then look at Rule 8, as it was in 1949, a member who, on ceasing otherwise than by reason of his death to be in the service of the corporation, is not entitled to a pension under the pension scheme, shall be entitled, he's not entitled to a pension under the pension, shall be entitled to receive a sum equal to the amount of his own contributions to the fund together with interest. And then there's a provision about the computation of that interest. So that's it. That's called withdrawal benefit. So that's withdrawal from service and is entirely consistent in not providing an annual pension with the approach taken in Rule 6. And as I showed you earlier, the way that that was changed is in Clause 2 of the deed at tab 3, page 40, where the Rule 8 that you just looked at is deleted and replaced by the one that I showed you, which gives you a right to election. And then on page 41, the B option is to be is a yearly pension computed in accordance with Rule 6. Rule 6, because it's been engaged in the case of an early leaver by the amendment to Rule 8, then applies to that leaving service pension, notwithstanding the words in the existing Rule 8 from the service of the corporation. There's no need for an amendment because, as is conventional in pension scheme drafting, you can apply what is said in the main normal retirement pension rule to a number of different situations, as long as you amend the other provisions appropriately, and that's what they've done. And the amendment power in 1949, we looked at, it's at, sorry, 14 to 15, thank you. Yeah. And there you have, you have the fourth proviso taking effect as regards any person not being a member. And I made my submissions earlier about how that works once you have the potential for a deferred pensioner created by the amendment in 1955. Naturally, they would fall under that protection at that stage without needing to amend the rule. Just in summary, your Ladyship's note, without going through the full history of changes, the term member with a little m changed to members with a capital M in the 30th deed of variation in 1996. See clause 16.2, reference supplemental bundle, tab 5, page 58. And then in 2000, it was replaced with the term active member. That's the 31st deed of variation, tab 6, page 65. Don't think we need to look at those. So, why did the draftsman, rather than making a positive change to the existing power of amendment and provide for the new category of deferred pensioner to go alongside the actives in the third proviso, choose to leave them naturally within the fourth proviso? That alternative course that I've just suggested would have been perfectly possible by introducing appropriate amendments, but that was not done. And so, as I've said, the objective intention is to be taken to be that deferred pensioners would fall within the fourth proviso. Why was it decided that there should be greater flexibility in the making of amendments that affected the interests of an active member as opposed to the interests of deferred members? The flexibility, as I've said, arises from the ability to offer substantially equivalent benefits, which is not provided for under 4, may be inapt in the case of past service rights. It's another pointer in favour of future service benefits being included in interest, that they talk of substantially equivalent benefits, we say. But also flexibility in terms of the relative ease of getting member consent through a majority vote as opposed to individual member consent under the fourth proviso.
Can I just ask you a question about that?
Yes, my lord.
Mr. Tennant suggested yesterday that the actuary had to look at each individual active member and decide whether his or her interests were or were not affected by a proposed amendment. And I wondered how that tied in with this idea that active members as a class can approve a proposed amendment. Is the actuary to approach the question whether active members' interests are substantially affected by looking at the active members as a class and comparing their position as a class before and after amendment?
My first answer to that question, my lord, is that could potentially be an interesting question that arises in the reserve matters. But my provisional answer to it is that it will depend on the nature of the proposed change. But if it is an across-the-board removal of future accrual or reduction in rate of accrual, that's a class change that applies to all active members. And the actuary will take a view on the effect across the class. That's my submission. It doesn't make any sense, and there shouldn't be any need to arrive at the broad judgment whether or not their interests are substantially prejudiced. They don't have to provide a precise value. It is a qualitative judgment that's formed there, and that, we say, can practically be applied across the class. And that being so, it sits with the procedure that's provided for as one of the routes under Proviso 3, namely resolution adopted at a meeting of such members convened by the trustees. And I think it's obvious that any of the benefit changes that the BBC might be contemplating that are relevant to the debate we're having now will be either across the board, applicable to all active members, or to particular groups or categories of active member. And you have to bear in mind that some members are accruing salary-related benefits on a final salary basis still, and some have career average benefits. And it may be that there will be a different proposed change in relation to the different categories. I just give that as an example. But wherever the change is directed at a group or a class, which is going to be the case, however big that class is, the assessment will be made across the class, I would suggest, by the actuary. That is the sensible a way to approach this, the working of this proviso.
Could I follow that up with a question? Where there are different categories of members with different interests, again, this may be a matter for reserve matters. The reference to the resolution adopted in a meeting of members is not necessarily all members, is it?
It's such members.
Yes. So
It's the members who the actuary has decided have interests which are substantially prejudiced.
well, or affected.
Or,
because
sorry,
that-
affected.
that's
Yes, yes, my lady.
And one could certainly see the argument, it would make perfect sense, that different categories of members might either, some affected, others not affected, or they may be affected in different ways. It would be odd if there
Yes.
wasn't the flexibility to have different meetings.
Yes, I would agree with that. I'm treading into
I
dangerous
appreciate
ground, not only because it's a reserve matter, but because unlike my learned friends who represent the two parties effectively to this deed, and their clients have been engaged with each other in relation to the workings of this scheme and various particular provisions of it for many years, I don't know what points may have been taken or what may have not been taken. I'm giving your ladyship straightforward, as I would see it now, looking at this provision submission. And
Yeah, I understand that. I mean, you're going back possibly to slightly safer territory in
Yes.
terms of the actuary's certification. Clearly, the actuary might consider they have to look at the position of different categories of member differently because...
yes, that logically they have to.
Yeah.
When I said that the actuary should look at a class in answer to my Lord's question, Justice Lewison's question, I'm talking about whatever the class is to whom the particular change applies in a particular way, and it may well be that the answer to the question as to whether their interests are affected, and if so substantially prejudiced, will be different for different groups of active members. And I would suggest that those groups where potentially there is that difference need to be looked at as a whole by the actuary, and the question answered in each case. It would make sense that the members who have the opportunity to vote under C are members of that particular group, but I'm not going to say any more than that at this stage for the reason that you've identified or I've identified. And so, returning to my submission on this, that the most obvious explanation for the location of the active members in Proviso 3 and deferred and pensioners in 4 is that the key distinguishing feature between those two respective groups is the fact that active members are able to accrue further benefits in the scheme rather than merely having accrued past service rights. That is the most obvious explanation. It would make sense for there to be some greater flexibility in respect of amendment that affect those future service benefits. And it's important to understand the general background that all pay negotiations, so that is elements of the remuneration package of employees at the BBC, not directly within the pension scheme, are negotiated and agreed collectively. So there is a collective process aimed at achieving a consensual result, and that's a process that's addressed at future remuneration policy, pay policy. As here, there's an element of consensus being sought for what we say are part of the interests protected by Proviso 3, namely the future service benefits. Obviously, it's equally applicable to the other part of the interests protected by the third proviso, past service benefits, which actives have, and in which they have a very strong interest, because they would rather not have what they've already earned taken away. They can't have that taken away now because of statute. But in terms of the idea which emanated from 1949 of at least there being the potential for them to agree to the removal of whatever their past service rights were at that stage, back to the debate we've already had, as well as their future service rights, makes sense. In principle, and with the thrust of what I've just said, the judge agreed. See paragraph 57 of the judgment. The BBC gives a different explanation. It says that the different treatment of the categories of member is best explained by the fact that the fourth proviso protects elderly and vulnerable pensioners. That is paragraph 43.4 of their skeleton. And as I've said already, that explanation doesn't explain the inclusion of deferred members within the fourth proviso. There's no reason to assume that deferred members are any more elderly or vulnerable than a pensioner. Then yes, sorry, did I? Yeah, thank you for correcting me. Then an active. The other point, which I think I will just try and pick up at this stage, because it fell at this stage in my learned friend's submissions, is how Section 67 may be able to help you over this problem in favour of the BBC. Essentially, the submission is that the idea that the pensioners go into the fourth proviso, neglecting really when making this submission to recognise explicitly that also the deferreds go into the fourth proviso, but the justification for the pensioners going into the fourth proviso compared with the actives in the third proviso is because he says not only under these rules but more generally pensioners get preferential favourable treatment under the legislation and also get preferential favourable treatment within this scheme in the winding up rule. Just to see if I can deal quickly with the section 67 point, so you can take away the references. The position is as follows. The effect of section 67 as originally enacted was to render ineffective or void any amendment that would or might affect accrued rights. And by the way, note that there was a particular statutory definition of accrued rights, which is not quite the same as accrued rights as they're understood when the Act doesn't apply. But in any event, those accrued rights were to be determined as if the member had left service immediately before the amendment. So, under the statute, accrued rights, as originally enacted, wouldn't include a final salary, whereas outside of the Act on the authorities, carriage, etc., they do. An amendment could be made under the original legislation if, in particular, the consent of every affected member was obtained and a majority vote was not sufficient. The provisions as originally introduced are at tab 3, 44. And you can see there, it's page 1059. You can see there under 67.2 that the power, that's the power of amendment, cannot be exercised on any occasion in a manner which would or might affect any entitlement or accrued right of any member of the scheme. Now that is not only pensioners or only actives or only deferreds, it's everybody. So at this stage, there's no favourable treatment afforded to pensioners. There was a change in that when the Act was amended, and the version of Section 67 that was in force at the time the 2000 deed was executed, which is when the fifth proviso was added, is at tab 44, 1059. One of the amendments was to render amendments to so-called subsisting rights voidable rather than void, although there were provisions for civil penalties. The other change was to make a distinction between something called a protected modification and a detrimental modification. You'll see that at section 67.2, authorities tab 45, 1062. A protected modification is defined at section 67A3. And a protected modification is voidable unless the consent requirements are satisfied. If you look at what protected modification means, you can see that sorry, let me make sure I get this right. Yes, it's 1065. It's a modification which would or might result in a reduction in the prevailing rate of any pension. So protected modifications are pensioners, and they can only be modified by the consent requirement. Yeah, in broad terms. The other type of modification is a detrimental modification, which is a modification, this is on 1066, which would take effect or might adversely affect any subsisting right of any member of the scheme. So that's deferreds and actives. And then if you go back to section 67.2 on page 1062, if the modification is a protected modification, you have to comply with the consent requirements. If the modification is a it is not a protected modification, so for example, a detrimental modification, either the consent requirements or the actuarial equivalence requirements need to be met. The point to take away is that in terms of consent, it doesn't make any difference whether you are a pensioner or, on the one hand, or a deferred or active on the other, because the consent requirements, if they're going to apply, are the same for protected and detrimental. The difference is that for detrimental modifications, which is the deferreds and the actives, essentially, there's also the actuarial equivalence requirements, which is analogous, if you like, to the substantially equivalent benefits within the proviso. The point, however, is that in the revised scheme of the legislation, deferreds and actives are treated the same way and pensioners are treated differently, which doesn't sit with my learned friend's thesis about proviso 4. If it did sit, the deferreds would be in with the actives and not with the pensioners. To the extent that he wants to rely on a submission that the reason pensioners are in proviso 4 is because generally they are treated more favourably, that doesn't explain why the deferreds are in there. And that's the short point from the section 6. It doesn't take my learned friend where he wants to go. I'm sorry that I ran over.
I'm sorry to be slow about this. We are being asked to construe a proviso to a power of amendment which has been in more or less the same form since 1949, and Mr. Tennant has laid particular stress on the continuity of that provision. I don't at the moment understand how a piece of legislation introduced 60 years after the drafting of that clause can help us understand what the clause means.
Well, I respectfully agree. I'm meeting a point made by my learned friend. He's using section 67 just as a demonstration of what he calls a sort of policy within pensions legislation, which incidentally only came into being in 1997, into force in 1997, but he's using that as an illustration of the similar sort of policy that maybe the draftsman had back in 1949. You only have to put it that way to see that it doesn't really stand up, but I've just dealt with the point because it's been made, my lord.
Right, Mr. Stone, how are we doing for timing?
We're doing reasonably well. I'm due to finish today, and I
Yes.
will finish today.
Right, so we will go into tomorrow with trustee submissions, you expect?
We may get to the trustee this afternoon. I need to think a little over the adjournment, how to proceed for the rest of the afternoon. You have my points already through my opening deliberately. I'm, as you can see, developing them and expanding on them to some extent in these submissions, but it may be that I can take things a little more shortly to enable the trustee to make their submissions today. And I think it's unlikely that we'll get through myself, the trustee, and a reply today.
Yes.
Sadly.
Thank you. Okay, so 2 o'clock, please.
Authorise it, Adrian?